Important topics that you should be revising for law of evidence can be character evidence, hearsay evidence, entrapment and confessions, right to silence. But this is the list that we believe have come up, the topics that usually come up on law of evidence exams from our experience. And you are highly recommended to have a look at your specific course, at your specific university exam past papers to understand what topics usually come up on your exam. But this is the standard topics that usually come up on English law university exams. Problem question style. It is important that you adopt the hierarchy structure, issue, rule, application, conclusion. You do not need to have an introduction and problem question. You can start directly discussing what is the legal issue, what is the applicable law, but do not become too descriptive. Most of the students make that mistake, and make sure that you avoid that mistake to not lose any marks. Then you apply the law to the facts of the case and you provide analysis. Finally, you need to conclude what would be the most likely outcome of this case, the problem question scenario that has been given to you. In the essay question, the structure can be a little bit different. Here you do have an introduction. You can start with definitions, depending on what the essay question is asking you. And then you need to argue both sides of the argument of the statement that has been given to you. Character evidence. Character evidence of a person with good character is relevant to their propensity to act in a manner consistent with that good character. Evidence of a person's character is also relevant to their creditworthiness. However, if there is too much reliance on character evidence, there can be prejudice. The jury may overestimate it. Because the person stole in the past, he must also be guilty in the current charges of theft. This is an example of character evidence. This is known as reasoning prejudice. When character becomes an issue, Section 101(1)(g) of the Criminal Justice Act 2003 allows courts to admit evidence of bad character to correct any false impression created. So good character evidence or bad character evidence can actually be biased for jury to make the decision. So sometimes they have to balance it. If there is a good character evidence provided, they may also introduce the bad character evidence to balance it out. Ferguson case is an important case that you should know about the character evidence. Here, the appellant was convicted for stealing pamphlets from a church, and he appealed on the grounds that there was a miscarriage of justice due to having cross-examined in previous conduct. The appeal was dismissed. This was because the applicant unintentionally introduced character evidence by stating that he attended mass and service for 36 years, and therefore the other party had the right to cross-examine him as to his character. Therefore, character evidence cannot be introduced all the time. It can create false impressions, and it depends on the circumstances and what circumstances character evidence can be introduced. R.V. Baker is also an important case. Here, the appellant was convicted for possession of malt with the purpose of making counterfeit money. The ground of the appeal was the evidence of the appellant's previous convictions was wrongly admitted. The appeal was quashed by stating that he had been earning an honest living for 4 years, and this was a good character evidence. This led him open to cross-examination of his character. Upon introducing good character evidence, the prosecution is then able to cross-examine the defendant as to his character. This will enable the prosecution to introduce evidence of the defendant's previous misconduct. Therefore, it is very important for the defense counsel to consider whether or not it is worth it to to introduce good character, because then the defendant may be cross-examined by the prosecution and all the evidence of the misconduct may come to light. Example essay question on this topic: discuss the extent, if any, to which the law on hearsay evidence in criminal cases requires reform. Hearsay is another topic that we have to discuss because it often comes up on law of evidence exams, and it is also come out as an essay question. You can see a full essay and answer here that we have on this topic. Before reading the answer, it is recommended that you try to answer this question yourself. You need to first define what is hearsay evidence, and then provide arguments for both sides, and then you can compare your answer to our answer. That would be a good revision practice. The principle is that hearsay evidence cannot be admitted in trial. Hearsay evidence is evidence of an out-of-court statement that is being used in court. These statements are made by witnesses that are unable to give evidence as witness in court. Civil Evidence Act 1995 and civil proceedings takes precedence in the rule against hearsay, whereas in criminal proceedings, it is the Criminal Justice Act 2003. The present essay will focus on the criminal aspects of hearsay evidence. As you can see, we have introduced the key statutes that is relevant to this area of law, and we have provided the definitions of what is a hearsay evidence. And now we will continue with case law. The case of R.V. Tapper signifies the unreliability of hearsay evidence in that it is not delivered on oath, the demeanor of witnesses is not visible, and that witnesses cannot be tested in cross-examination. So this is introducing the issue in every essay question that you have, not just in law of evidence, but in everything. You need to introduce the main issue of the topic at hand. The main issue of hearsay evidence is that it is arguable to what extent hearsay evidence is credible. It is not delivered on oath, and it is not visible, and that witnesses cannot be tested in cross-examination. Those are the cons of hearsay evidence. This is just the start of various problems that face hearsay evidence, and as a result has led many to call for reform in this area. It should be argued that the law on hearsay evidence in criminal cases require reform to an extent as it would help in achieving the overriding objective as set out in Section 1(2) of the Civil Procedure Act, Civil Procedure Rules, which is to deal with cases justly. Prior to the 2003 Act, the cases was dominated by the law was R.B. Curley. In the case of R.B. Curley, the court decided that both implied assertions and purpose assertions should be caught by the hearsay rule. Purpose assertions being out-of-court statements where the person makes a statement to cause another to believe the matter, and implied assertions being out-of-court statements where we would be able to infer as an assertion from words or conduct. Following the 2003 Act, implied assertions are no longer caught by the hearsay rule. Section 114 of the Act provides 4 categories of the exception to the hearsay rule. The court rule confirms this in both R.V. Singh and R.V. Midmore. In these cases, the reasoning for the decisions was that the absence of purpose in out-of-court statements removes the risk of insincerity. This technique can be criticized, and insincerity is only one danger of hearsay evidence, whilst the dangers of lack of clarity and faulty perceptions in narration have been ignored. Therefore, as you can see, here we have introduced the case law. So the case law that took place before the 2003 Act and after the 2003 Act. And we have said what has been held in those cases and what has changed, and provided some critical analysis of what are the reasonings of the decisions and on what basis it can be criticized. Therefore, the CJ A 2003 can be described as a positive development regarding Hersey evidence. Nevertheless, there is still a further need for reform. So it is important that not only you describe the relevant law, but you also say how is it the law described, answering the question asked, the question, and you need to provide critical analysis. Hersey evidence is notes on this topic can be seen at this link, and here are some basic facts that you need to know. Hersey evidence is evidence of an out-of-court statement that is being adduced in court. Hersey evidence in civil proceedings is dealt with by Civil Evidence Act 1995, and for criminal proceedings is Criminal Justice Act 2003. The rule against Hersey provides that Hersey evidence is not admissible. The rule is not defined anywhere in statute and is not actually applicable in many circumstances, as we shall come to see. Tapper versus R is an important case. You should have a look. Here it was about Hersey evidence. The appeal was allowed. This case highlighted the unreliability of Hersey evidence. The court said that Hersey evidence is not delivered an oath and the witnesses cannot be tested in a cross-examination. So in an essay question, when you say that the Hersey evidence is unreliable because it's not delivered an oath and it is not subject to cross-examination, it is important that you cite the relevant case, and the relevant case with that principle can be Tapper versus R. So make sure that you cite the relevant cases for everything that you say. Important case law that I suggest you read. It is available for free, and you can go to these links and read those case law after the session. Confessions is also an important topic that you should be revising. Section 76 is the main law about confessions. This is when, if any proceedings where the prosecution proposes to give an evidence, a confession made by an accused person is represented the court that the confession was or may have been obtained by oppression of the person who made it, or in the consequence of anything said or done which was likely in the circumstances existing at the time to render unreliable any confession existing at the time to render unreliable, which might be made by him in consequence thereof. So in this case, the court shall not allow the confession to be given. Therefore, there are two grounds for mandatory exclusion for confessions. One is oppression, and the other is anything said or done which was likely in the circumstances to make any resulting confession unreliable. You need to note that the grounds for mandatory exclusion focus on the conduct of the police, not on the evidence that has been produced. Prohibition of oppression. Oppression includes torture, inhuman or degrading treatment, and have a look at section 76(8) for that. RV Fulling is also a case to define what is oppression, and in section 76(2)(a) should be given its ordinary dictionary meaning. The Oxford English Dictionary says that it's exercise of authority or power in a burdensome, harsh, or wrongful manner. To sum up, you need to analyze your exam requirements. You need to do your selective studying, practice answering problem and essay questions, and make sure that you follow your professor's guidelines. Now I'd like to give you a little bit of information about how we can help you to prepare for your law of evidence exam or coursework. We're a team of law graduates who have achieved high to 1 and first class grades in our exams and for law degrees. And we have created simple study resources focusing on specifically getting high grades. We help students achieve first class degree or generally high grades by giving them the right resources that helps them focus on the right information they have to know to achieve high grades. Our revision notes, example essays, tutorial videos, quizzes, flashcards are all specifically designed for students to get high grades in the simplest way possible. If our resources are not enough, we suggest you have a look at our tutoring services. Tutoring services is a one-to-one support for students from one of our tutors that will, and we will help you achieve high grades with a personalized support. We can help you practice your legal writing skills, help you prepare for your exams, or help you do legal research, whatever you may be struggling with your legal studies. We will help you to overcome the struggles and achieve good grades. We've already helped thousands of those students get high grades. You can see the reviews, and our regular students usually get a first class. The regular students are the students who regularly study with our SimpleStudy resources, as well as get tutoring sessions. We would like you to be our next student to get high grades. Please join SimpleStudying. Thank you very much for your attention.